started. Could everyone please take your seats, or if you want to continue your discussion, you could move it outside. This room is difficult to hear everything in this room. The acoustics are not that great. This is the Planning and Land Use Management Committee. I'm Councilmember Jose Huizar. We've been joined by Councilmember Marquise Harris-Dawson, Councilmember Mitch Englander, and Councilmember Felipe Fuentes. We will start off with the consent and continue calendar. Let's start off by on item number 9. We're going to continue that. Item number 9, we're going to continue that to a date uncertain. So item 9, continue to a date uncertain. Item number 2, we could approve on consent. Item number 7, approve on consent. Item number 10, we'll hear in just a moment. Item number 1, we could call item number 1 to order, please.
Sure. Item 1, Councilman, this is the Director of Planning's weekly report, and the Director of Planning is present.
Thank you, Chair Huizar and members of the committee. Vince Bertoni, Director of City Planning. Just wanted to bring up 2 quick items. When I did my update last week, I don't believe I mentioned when I gave the committee an update of some of the recent development projects heard by the City Planning Commission, that the Paramount Studios master plan had been heard by the Commission on July 14th, and that is a master plan that will allow over time around 2 million square feet of new stage and production office facilities, required a general plan amendment and zone change. There's a development agreement that's associated with that with $9 million in community benefits, and that will be coming to this committee in the near future. And another item, which was on last week's City Planning Commission meeting, was the commission had heard and recommended approval regarding the Reef Project, and that's a project in South Los Angeles located near the intersections of Broadway and Washington Boulevard, and it includes turning surface parking lots into about over 1,400 dwelling units. There's a 200-plus room hotel, grocery stores, retail, and restaurants that were associated with that. They will be providing they're proposed to provide some money, about $15 million to maintain affordability of housing units nearby, as well as doing a certain percentage on site of low-income housing. There's also a signed district associated with that. So that's recommended, as well as a development agreement. That's recommended approval by the City Planning Commission, and that will be making its way to this committee. And with that, I conclude my report, and I'm happy to answer any questions.
Great, thank you. Are there any questions or comments for Mr. Bertoni? Seeing none, okay, we will now receive and file item number 1. We could move to item number 10, please.
Sure. Item 10, Councilman, this is a hardship exemption application from the Baseline Mansionization ICO, and it's for a proposed 1 additional story to an existing single-family residence in CD4.
I understand that the applicant has yet to submit an affidavit certifying that he or she has completed the noticing requirement for this item, and so therefore we will deny this ICO hardship exemption without objection. So ordered. Item number 8.
Item 8, Councilman. These are 2 appeals that have been filed by the property owner and by the operator as it relates to a zoning administrator's imposition of conditions and revocation of the use of a cocktail bar in CD13.
Okay. Staff here on this item? Alita James from the City Attorney's Office. City Planning, okay. Welcome.
Good afternoon.
Good afternoon.
Alita James, Associate Zoning Administrator for the Office of Zoning Administration for the Condition Compliance Nuisance Abatement Revocations Unit. In reference to case number DIR 2016-0824 RV Revocation Discontinuance of Use for the project address at 6360 through 6366 West Hollywood Boulevard, also including address number 1646 North Cosmos Street in Hollywood planning area. On Tuesday, May 10th, 2016, a public hearing was held in City Hall Room 1070 to discuss the possible imposition of conditions to abate a nuisance or revocation use for the operation known as Cosmo Nightclub, located at, again, 6364 West Hollywood Boulevard in the Hollywood Community Plan area. To highlight a few of the frequently violated CUP conditions as noted on the notice of public hearing, I'd like to note there was a failure of security guards to wear distinctive uniforms, a failure to utilize electronic age verification devices, subletting of the premises to outside promoters, improper notification to the Los Angeles Police Department of private parties, failure to adhere to mandated closing time, allowance of amplified music to extend beyond the premises. In addition, the multiple criminal and nuisance activities occurred on the site, which included a discharge of a firearm in the city, assault with a deadly weapon, aggravated assault, narcotic, drug violations, sale of alcohol to an obviously intoxicated person, presence of a minor inside the premises in possession of alcohol beverage, public nuisance, public intoxication, theft, vandalism, and noise disturbance. A conditional use permit is currently in effect at the site and the location under case number ZA 2013-0832 CUB-CUX, which permits the continued sale and use of a full line of alcohol beverages for on-site consumption in conjunction with an existing cocktails bar/lounge, and to permit the continuation of public dancing. The grant entitlement is for a 3-year period of time, which was effective September 3rd, 2013, and will expire September 3rd, 2016. At which time the applicant will then be required to file or seek the authorization or the approval of a new sale of alcohol and beverages on site and also for dancing. Prior to the public hearing on Thursday, March 17th, 2016, between the hours of 9:30 p.m. and 11 p.m., the planning staff, accompanied by approximately 5 Los Angeles Police Department officers, conducting a field analysis as part of this nuisance investigation. The operation was found in partial but not full compliance of the 2013 conditions as stated. At the time of the site visit, there were at least 5 patrons in the establishment. The manager noted to staff that normally there would be, at any time, there would be between 10 and 15 people who would be seated at a total of 12 tables. Violation of the CUP confirmed during the field investigation are as follows. Condition number 14, the club manager stated that there had not been any advertisement for the disc jockey. However, the Cosmo website and social media pages did advertise DJ entertainment, and the date stated is April 22nd, 2016, as noted in the staff report. Condition number 18, the establishment was open for the public and there was no security guards present at the time of the site visit. The manager said that they were on break and one had not yet arrived. The club manager said the guards usually start their shifts at 9:50 p.m. Condition number 18 requires that a minimum of 2 state-licensed security uniform guards be present between the days of Sunday through Thursday, and a minimum of 3 security guards on Friday and Saturday. Guards shall begin their duties a minimum of 30 minutes prior to the opening of the facility and remain 30 minutes after closing. Condition number 22, the club had an age verification device, which the club manager said security/personnel use at the door when patrons come in. The age verification device was not working at the time of the site visit. The manager had a backup age verification device on a smartphone that was operational. Noted that condition number 22 requires that the electronic age verification device be installed on the premises and at each point of sale location, and that the employees be made knowledgeable of the operation of such devices. Condition number 27, club manager was unable to produce proof of STAR training at the time of the site visit. However, he provided proof in the form of a letter submitted by email on March 23rd of 2016. Condition number 31, the name of the on-duty manager, at this time it was Matthew Goldsberg, was listed that the name be listed of the manager in a conspicuous place near the entrance of the business for view. However, the hotline number listed revealed that the main number of the club with a recorded message allowed interested parties to leave a message. Condition number 31 requires that the phone number serve as a hotline number for contact regarding any complaints that the facility operation. The Planning Department has received multiple arrest records, crime analysis documentation, and calls of service reports for the subject site from the Los Angeles Police Department, covering a time period of January 9th, 2014 to April 25th, 2016. Reports received from the Los Angeles Police Department from the operation known as the Cosmo nightclub indicated that there were 24 arrest and investigation reports which were submitted for the property and near the property between the dates of January 7th, 2015 and April 25th, 2016. 19 arrest charges submitted to the property between January 9th, 2014 and February 27th, 2016. 12 crime charges submitted to for the property between October 9th, 2014 and March 10th, 2016. 19 calls for service submitted for the property between May 28th, 2014 and March 10th, 2016. Of the 24 arrest and investigative reports submitted to the property and over a 15-month period of time between January 1st, 2015 and April 25th, 2016, the property owner-operator were cited for multiple violations of the CUP case number ZA 2013-0832, CUB-CUX. The most frequent condition violations occurring on the property are as follows. Condition number 12, the facility leased or rented out to promoters. Condition number 17, cover charge or prepayment for admission to premises. Condition number 18, security guards not state licensed and not uniformed. Condition number 21, music, sound, or noise was audible beyond the subject site, as well as the violations of conditions numbered, condition number 7, overcrowding. Maximum occupancy was not to exceed 130 persons. Condition number 22, use of an electronic age verification device, which also can be used to determine the age of any individual attempting to purchase alcohol beverages. Condition number 23, CUP approved of conditions shall be retained on the property at all times and produced upon request of the zoning administrator, police department, and building and safety. A copy of said conditions shall be provided to all employees who shall sign and acknowledge the form. Form shall be maintained at the location. Violations also include condition number 26, the applicant owner and or site manager shall comply with all applicable laws and conditions and said properly manage the facility to discourage illegal and criminal activity on the subject premises. Condition number 27, all employees involved with the sale of alcohol beverages shall enroll in the Los Angeles Police Department's standardized training for alcohol retailers, or the STAR program. Condition number 31, name of on-duty manager shall be listed in a conspicuous place near entrance of building. The phone number shall also serve as a hotline to register any complaints of the facility's operation. Condition number 8, hours of operation shall not exceed 6 p.m. to 2 a.m. daily. Condition number 9, no after-hours use of the facility shall be permitted. Condition number 14, a disc jockey is permitted in the mezzanine area. There shall be no public advertising for any disc jockey entertainment at this facility. And condition number 10, the premises shall not be exclusively used for private parties, including promotional events of which the general public is excluded. The premises may be used up to a maximum of 12 times per calendar year for the private events. As presented in this information, documented through correspondence and public testimony by affected parties, it was determined that the operation of the nightclub known as Cosmo has created a public nuisance and impact at the site. Findings were made in the affirmative that the operation jeopardized and adversely affect the health, peace, and safety of persons working and residing in the surrounding areas. Condition number 36 placed on the, there were 36 conditions placed on the operation per ZA case 2013-0832 CUB-CUX, and they were put in place to preserve the health, peace, and safety of the persons working and residing in the surrounding area. The public record, including arrest reports and testimony at the public hearing, indicated that there have been documented ongoing violations of these conditions, in addition to the violations of State of California ABC license. Serious and violent criminal activities have taken place at the site and at the location adjacent to the site, involving patrons and staff of the Cosmo nightclub. These activities appear to be increasingly frequent over the past year. Findings were also made to constitute a public nuisance. There are considerable impacts from the use of this site from the surrounding neighborhood. These include assaults, discharge of firearms, lack of compliance with the conditional use permit, and the State of California liquor license. Most evident was the public nuisance is the noise disturbances originating from the location and threats to public safety from the history of the violent crimes that have taken place at the site. The neighboring business, known as I.O. West Club, testified at the public hearing as to the financial impacts that they have experienced with a decrease in bookings and attendance, from which they believe are directly associated with the negative role played by the Cosmo nightclub. The use has generated a considerable amount of required resources from the Los Angeles Police Department. The need for continued investigation has been a drain on the department's resources. Findings were also made resulting in reported nuisance activities. As noted earlier, the Los Angeles Police Department has documented numerous and ongoing violations of the conditions imposed by the zoning administrator under said case ZA 2013-0832 CUB-CUX, including noise audible beyond the premises, security guards not having state license and not wearing distinctive uniforms, lack of STAR training, lack of notification to the Hollywood Vice of private parties, admission being charged to enter the premises, and the facility being leased to outside promoters. Findings were also made regarding the violated provisions of this chapter, the Los Angeles Municipal Code, Administrative Nuisance Abatement Proceedings, and other city, state, and federal regulations, ordinances, and statutes. The record includes a detailed account of the Los Angeles Police Department investigations and arrests concerning the Cosmo nightclub, including violations of conditions imposed by both the City and State of California Alcohol Beverage Control. In addition, arrests of Cosmo business owners, management, and employees have been made aware, have been shown to include possessions of narcotics, allowing a minor inside of the premises, service of an overly intoxicated person, failure to have a valid security guard card, certification of outstanding warrants. Findings were also made that prior governmental efforts to cause the owner or operator to eliminate the problems associated with the use or discretionary zoning approval have failed. The Cosmo nightclub has placed a heavy demand on the limited Los Angeles Police Department resources and has resulted in over 20 separate arrests and investigative incidents since December 13, 2015. The governmental efforts to cause the owner or operator to eliminate the nuisance problems associated with the use and to achieve conditions compliance have failed, as documented by the excessive and repeated number of arrests, investigations, and calls for service by the Los Angeles Police Department. Many of the documented violations are repeated violations which have occurred over a short period of time. There have been no discernible improvements of the operation subsequent to the repeated action of the police department conducting investigations and making arrests at the site. There has been no demonstrable effort to correct or address any of the violations identified. The business operator and the management of the Cosmo have been given numerous opportunities to demonstrate an attempt to comply with the conditions and address the issues of public nuisance at the site. In addition, findings were made that the owner-operator has failed to demonstrate the willingness or ability to eliminate the problems associated with the use of the discretionary zoning approval. The current business manager and the legal representative of the business owner attended the public hearing date May 10th, 2016. Many of the crimes submitted in testimony which had taken place at the location were denied. Also, many of the CUP violations were also denied. In some testimony, there was acknowledgement of connection of the Cosmo nightclub to nuisance activities originating from the site. However, the seriousness of such activities was dismissed or downplayed, as indicated by the February 26, 2016 incident in which a former patron of the Cosmo had attacked the business manager and was subsequently attacked by the Cosmo staff, resulting in an 8-inch laceration to the chest and one member of the Cosmo staff intentionally struck by a car, all taking place on a city street adjacent to the club. The incident was described as a small altercation. The business operator and the management have continued to take no responsibility for most of the public nuisances originating from the location, including most of the CUP violations. No constructive measures to alleviate the public nuisance associated with the site were proposed by the property owner, operator, or employee. Therefore, there continues to be no demonstrable effort to correct or address the violations and public nuisance at the location by the property owner, business management, or employees. The zoning administrator found that the repeated administrative attempts to approve the operation of the cocktail bar/lounge with the associated alcohol use has not resulted in the elimination of problems associated with the use, and therefore ordered the discontinuance of the operation known as the Cosmo. In this case, again, the business owner and operator have had multiple opportunities to address the allegations and documented reports of nuisance allegations occurring on the site or adjacent to the site, and have failed to respond or eliminate said nuisance activities. Again, as a zoning administrator acting in a quasi-judicial capacity, the authority is given should findings be made to revoke a permit lawfully granted. Due process requires that notice be given to the permittee upon which a hearing was issued or noticed and mailed properly to the property owner, business owner, and the property address. And upon evidence, also substantially finding and supporting a revocation action, which was received through the Los Angeles Department of LA City Police Department, from arrest reports, crime data analysis, and calls for service to the property location. The business owner or property owner has renovated the property and proceeded in good faith based upon permits received, also including a conditional use permit and the 36 operating conditions. Staff therefore recommends that the council uphold the zoning administrator's action and deny the appeal.
Okay, thank you for that. Any questions for staff? No questions at this time? Yeah, we're going to have LAPD up. Is that fine? We'll hear from LAPD. And then the appellants, and then general public comment. Corey Paca from Police Department, Officer Benjamin Thompson afterwards, and Detective Dana Harris. Welcome.
Good afternoon. I'm Corey Palka, the Area Commanding Officer at Hollywood Division. You know, I had lunch today with a developer named Camby's Marabi, who owns several real estate holdings in the San Fernando Valley, and he's considering investing in Hollywood, a multi-million-dollar investor. His concern, like most of the investors who come into Hollywood, is public safety. Can I assure him through public safety that we can help him develop and prosper as he invests in Hollywood? In order to continue and sustain public safety and to continue the economic growth in Hollywood, we need compliant partners. We need business partners who will meet with us, who will greet us, and listen to what we know as being true to operate successfully a business in an entertainment venue. This client, the Cosmo, has not done that. We have repeatedly tried to partner with them, give them the opportunity to be successful so we can grow the economy, so people can invest in Hollywood. And the reality is when I look at my anchor points in Hollywood, we draw a circle around the intersection where the Cosmo's at, and I can show you repeated violent crime in and around that neighborhood because of their failed compliance, their unwillingness to be a good partner. I need to continue the economic growth in Hollywood with good partners and good investors. and the Cosmo just has not been one of them. Thank you.
Thank you.
Good afternoon, council members. I'm Officer Benjamin Thompson, serial number 39467. I'm here today representing the Los Angeles Police Department on the appeal matter that is before you. I'm a vice investigator for the department, and I'm currently assigned to the Hollywood area vice unit. I've been investigating vice conditions and providing regulatory oversight of the various alcoholic beverage retail establishments that operate in the Hollywood area for over 2 years. I've had extensive experience with the Cosmo operation, and I'm one of the lead investigators of a comprehensive and long-term investigation related to chronic misuse of the retail premises. Hollywood Vice investigators have been negotiating inspections of the Cosmo premises for over a year now. These compliance inspections were precipitated by a series of community complaints regarding nuisance activity associated with a venue and pursuant to the increase in the occurrence of violent crimes immediately around and inside the subject premises. Early inspections of the operation substantiated the reported Cosmo nuisance activity, and early research indicated that this nuisance activity was a contributing factor in the overall amplification of criminal activity in the Hollywood Entertainment District. During initial site examinations, officers encountered conspicuous and seemingly blatant operational deviations that motivated further scrutiny, as investigators were compelled to repeatedly examine the premises for the purposes of inducing operational compliance and mitigating negative impact. Over the course of this investigative period, investigators found that the Cosmo business was in consistent violation of the following conditional use permit conditions. Condition number 17, which states there shall be no cover charge or prepayment required for admission to the premises. Conditional use permit condition number 18, which pertains to security guard licensing and uniform requirements. Conditional use permit condition number 21, which prohibits the operator from allowing music to extend beyond the subject premises. Conditional use permit number 10 requires that the operator not use the premises exclusively for private parties and provide a 7-day notification to the Hollywood area vice unit prior to using the property for a private event. Conditional use permit number 12 mandates that the facility shall not be leased or rented out to promoters at any time. The operator shall at all times retain operational control of the premises and utilize only the facility's regular employees, own security staffs, and bartenders for any event. Repeated inspection of the Cosmo venue has revealed that all these individual conditional use permit conditions are routinely disregarded by the establishment operator and the operator's agents. The Cosmo conditional use permit is comprised of 36 operating conditions regulating and restricting use of the property the establishment is connected with. The 36 conditions essentially consist of operational requirements that were imposed to ensure the mode and character of the establishment remains consistent with the cocktail lounge and bar that it was proposed to be when the grant was issued. These conditions additionally serve to mitigate nuisance impacts from use of the facility and provide an operational framework to enhance public safety. The Cosmo function is not directly and individually regulated by the conditional use permit, but also by the California state-issued alcoholic beverage control license, which authorizes the operator to distribute alcoholic beverages in a commercial capacity. The Cosmo Alcoholic Beverage Control License contains 19 operational conditions regulating exercise of the license privilege. The majority of the Alcoholic Beverage Control License conditions resemble the conditions delineated in the Cosmo Conditional Use Permit and restricts use of the premises in similar fashion. Similar to the style in which a Cosmo operation is routinely found to be negotiating business in violation of the governing conditional use permit, the venue operation is often functioning in concurrent violation of the associated alcoholic beverage control license. Since January 7th of 2015, which marks the date that Hollywood Vice Unit began to perform inspections of the Cosmo facility with regularity, investigators have repeatedly observed that the Cosmo establishment is consistently operated in violation of alcoholic beverage control license conditions 2, 6, 17, and number 18. Number 2 prohibits the operator from mandating or requiring a admission charge or cover fee. Alcoholic beverage license condition number 6 mandates that sale and delivery of alcoholic beverages to customers shall be made from behind a counter where a clerk will obtain the product. No self-service of alcoholic beverages will be permitted. Alcoholic beverage control license condition number 17 specifies that entertainment provided shall not be audible beyond the area under the control of the licensee. And alcoholic beverage control license condition number 19 requires security guards to be licensed and uniformed in a readily identifiable fashion. From January 7, 2015 up to the present, Hollywood Vice investigators have inspected the Cosmo premises on 27 separate occasions. In 23 of those inspections, investigators took enforcement actions against the Cosmo operators and management staffs for violations of municipal code ordinances and state laws that regulate commercial function. During this time period, Hollywood Vice investigators observed the Cosmo premises to be operated in violation of Conditional Use Permit condition number 17 on 12 different occasions, with 3 of those instances occurring after May 26, 2016, when the revocation of use decision was announced. Investigators observed the premises to be operated in violation of Conditional Use Permit number 18 on 10 different occasions, with 2 of those instances occurring following the revocation decision. Investigators observed the establishment to be operated in violation of Conditional Use Permit condition number 21 on 6 different occasions, with 1 of those instances occurring following the May 26 revocation of use decision. Over the course of this entire investigative period, investigators have found the Cosmo premises to be operated in violation of Conditional Use Permit number 10 on 3 separate occasions, Conditional Use Permit number 12 on 2 separate occasions, Conditional Use Permit number 22 on 2 separate occasions. During the involved 27 site inspections, investigators also observed the premises to be operated in violation of alcoholic beverage control license condition number 2 on 4 separate instances, with 2 of those transpiring after the revocation of use determination was issued, of alcoholic beverage control license condition number 6, with 3 separate instances, with 1 of those occasions transpiring after the revocation of use decision was issued, of alcoholic beverage control license condition number 17 on 4 separate occasions, with 1 of those instances transpiring after the revocation of use decision was issued, and of alcoholic beverage control license condition number 19 on 3 separate occasions, with 1 of those instances identified after the revocation decision was issued. Over the course of Hollywood Vice's scrutiny of the Cosmo operations, investigators have found the facility to be operated in violation of numerous other regulatory statutes aside from the Conditional Use Permit and alcoholic beverage control license operating conditions. On 2 separate investigative occasions, Vice investigators discovered Cosmo management staff to be allowing patrons of minority to enter and remain in the Type 48 licensed premises in violation of Business and Professions Code Section 25665 and took enforcement action as a result of the discovery. During 3 different site examinations, investigators arrested establishment security guards after finding that the involved employees were unlicensed by the Bureau of Security and Investigative Services in violation of Business and Professions Code Section 16240. The most recent of these security guard arrests was effected on July 22nd, well after the revocation of use decision was rendered. Investigators have also arrested Cosmo security guard employees on 2 separate occasions for outstanding misdemeanor arrest warrants and have arrested an establishment manager for employing proprietary security employees without having obtained a California state license or endorsement to do so in violation of Business and Professions Code Section 7574.12. During one previous inspection, investigators arrested an establishment bartender for a violation of Business and Professions Code Section 25602, subsection A, providing alcoholic beverage service to an obviously intoxicated person. While engaged in another prior inspection of the venue, investigators arrested an establishment manager for a violation of Health and Safety Code Section 11350, subsection A, possession of a controlled substance. And while negotiating another recent examination of the premises, investigators arrested an establishment patron for selling an undercover vice officer narcotics in violation of Health and Safety Code Section 11352, subsection A. My investigation of the Cosmo operation thus far has revealed that the operator has operated and continues to operate the Cosmo venue in willful and blatant disregard of the legal requirements imposed on the business function and use by the City of Los Angeles and the State of California. Outreach attempts and traditional enforcement methods have proven to be ineffective in this case, and it appears that the operator is intent on conducting business in violation of the regulations that the operator initially agreed to adhere to, and at the risk of legal repercussion and detriment to public safety. For the foregoing reasons, the Los Angeles Police Department respectfully requests that you affirm the revocation of use determination that was rendered by Zoning Administrator Alita James on May 26, 2016. Thank you very much.
Thank you. Thank you. Any questions here? No? Okay, no questions. Detective Dana Harris, welcome.
Good afternoon. In the interest of time, I'll be brief with my comments. As the officer in charge of the Detective Support and Vice Division Nuisance Abatement Unit, I have known, or I've seen this club just be in constant violation of not only the alcohol beverage control, the calls for service, the nuisance-related crimes, but what I'm most concerned about is the crimes of violence which are occurring. The sexual assault, the stabbings, the assault with a deadly weapon, and just as important, the two separate driving for under the influence of alcohol after leaving Club Cosmo. Again, I agree with my coworkers, and I would ask that you uphold...
Can you hold your testimony, please? Just as a general policy, we ask those who are filming in here if you could not use the bright flash or lights. If we have a few of those, it kind of disrupts public speakers and others from speaking. Thank you.
Again, in closing, I would ask that you uphold this revocation. Thank you.
Great. Thank you. Thank you very much. So we have two appellants. We will go first to one set of appellants and their representatives. Michael Ayaz, Rick Blake, Michael Coladzi.
Councilmember, I believe one of the appellants withdrew their appeal. There's a letter regarding the appeal filed by Mehdi Balour and Palmer Building Associates indicating that the appellant has decided to withdraw that appeal.
Okay, so is that the same with Sean?
No, those are
that's the same part. That's the same. That's the same appeal, right? Sean is with you. Okay.
correct.
Typically, we have appellants give them an opportunity of 5 minutes to present their case. Here, you have the opportunity also to submit individual cards for public comment. So you have 3 here. You could have 5 minutes plus 1 minute for each, which is a general public comment. So you could have a total 7 minutes on, if you so choose, on here. So
Thank
7
you.
minutes for the 3 of you. Thanks.
Oh, before the 7 minutes starts, I'd like to object to that on the record. We've just given the city about 15 to 20 minutes to present their case, and given the gravity and the complexity of the case, giving us 5 to 7 minutes to make our case is yet another.
Okay, sir, thank you.
due
Unfortunately, we will have to start your time, and
I'll just note it for the record.
you could state that on the record when you begin your time. Thank you.
Thank you. Well, then we will take the 7 minutes, or actually 6 minutes will be fine. Again, I object to the process in which we are not allowed the equal opportunity to defend ourselves. Obviously, you've given the police and the planning department plenty of time to present the case, and it's just another indication that this body is not an independent hearing body, and we're not getting the due process that we deserve. We've submitted a brief to you, to the council. I hope that you've read it, or I certainly hope that you do read it before you render a decision. I think given our time limitation, it's imperative that you do that, because it sets forth a lot of things that we're not going to be able to get to today. First and foremost, my client was denied due process, and we still live in America, and the Constitution of the United States and the California Constitution still apply. And during the initial hearing, and we've heard testimony from the hearing officer with new facts that were never presented to you, presented to us before, let alone at the ZA hearing, but here today, we asked for a postponement so that we could adequately prepare, only having been retained 6 days prior. We were similarly denied that. This hearing officer allowed testimony into the hearing record that you folks will review that we were not provided in advance, so that we could adequately prepare, again violating our due process. Our equal protections were also violated in that the ZA is merely carrying out the edict of the city council members, the particular city council member, the LAPD, the CCU, and other agencies within the city. There is an element of race that's in this, that we have a video that we'd like to show, but we've been basically told that might not happen, where the BID, a committee that is sanctioned by the city, talks about too many blacks, browns, and people of lower income strata coming to these clubs and into Hollywood, and wanting to have the Lindsay Lohans of the world coming to this place. And she's by no means any queen of responsibility. The hearing officer was biased, which was apparent from the very get-go. She is apparently a member of the planning staff. There is no safeguards between the zoning hearing office and the planning and the CCU. She is supposed to be a judicial officer and have an independent review of this, but that is by far not happening here. She is part of the process and the clandestine effort from wherever this is coming from to eradicate these types of businesses. She has to be an independent hearing officer, and her testimony today and her actions show that she is not an independent hearing officer. This applicant has been condemned before convicted. You heard them repeat and repeat and repeat crimes that have never been adjudicated. There's been not one case that has gone to court and a judge of competent jurisdiction or a real judge has not found our client guilty of one single thing. The ABC has not cited my client for one single thing. The Los Angeles Police Department has no jurisdiction to talk to you about things about alcoholic beverages because the ABC has its own peace officers that do that. And again, that agency, a state agency that actually has a separate judicial officer review, has never even cited my client. There is an ancestral relationship between all of these parties that are here before you, with the most of shocking should be the zoning administrator. They're supposed to be independent of the planning, the Department of City Planning, the CCU. How can that be when the CCU officers also act as ZAs, which we've also included in our original, we've also stated in our original record? The ZA could not have reached the required findings to revoke this permit. The police department has made no effort to make outreach to us. They have not provided a single email, letter, anything to you folks that can establish the fact that they've actually made attempts to meet with us. What they've done is, instead of going through the normal plan approval process, and in fact, in our brief, you'll see an exhibit that's an attachment from Aletta James, who used to be a planner and now is a ZA, where she sets forth the nuisance abatement process. And before you get to the ultimate revocation, which is essentially a death sentence for my client, you have to go through certain steps. And those certain steps are codified in 1227.1. They have to go in for a plan approval. They have to give these people some kind of bureaucratic option to remedy these situations. They went straight for revocation. They went straight for the throat, because we know, and the reason that they did this intentionally is because there is a hit list for certain clubs in Hollywood, and this hit list, we don't know how we get on this hit list. We don't know who the king is of Los Angeles that's putting people on this hit list, but it does exist, and when this matter proceeds, if it has to, we will find out. Again, the city has to allow for the plan approval, or at least a bureaucratic option for something, instead of going straight for revocation. You're talking about taking a person's right away, a constitutional right of millions and millions of dollars that they've invested in this property. There is no nexus, or they've made no attempt to show a connection between what happens with an open container down the street, or a shooting that may have happened 6 blocks away, or something that happens at one of the other 5 or 4 clubs that are in the same exact building. You cannot pin all of these things on this client. There has to be a nexus. The Constitution requires there to be a nexus before you take away someone's constitutional right. None of the claims, and again, as they said, we will take credit where credit is due when we do stuff wrong, but not to the degree where you just come in and take away the business without making any efforts to talk to us, and then, on top of it, assigning crimes that happen outside of the premises to our client. This is Hollywood Boulevard. This is a busy, busy, busy entertainment district. This is not a very quiet area. And to say it's noisy on Hollywood Boulevard is almost laughable. The judge, the criminal judge, laughed at these tickets, and the attorney handling that will talk about that. There's a bid video, and that's what we intend to show in one of our follow-up minutes, where the bid is talking about no blacks, no browns, and people of lower income strata should not be coming to Hollywood. Is that the legacy that this committee wants to have? Instead of working with people, instead of lying about working with people, make them work with us and let us save our business. There's employees, there's taxes, there's many things that are happening here. There's also in their staff report some connection with Kashmir, and that is wholly inappropriate. These are two separate entities, and we cannot be guilty by association. That is incomplete. It's just frustrating. It can't be done this way. We do not live in a communist country where this can happen, and thank goodness we have the court system that at least we have to rely on. We don't know what the impetus of this is. We have our suspicions, but these are certainly not driven by neighbor complaints. These are not resident complaints. You have one neighbor that's entered testimony, and in that testimony it's very telling. 16 bullet holes in my wall, but there's no police reports that go to that. Plus she's not a neighbor. If there were 16 bullet holes, why aren't there reports for that? Why didn't those people make any kind of claims? There's no resident complaints. The police are driven and acting as the henchmen of other agencies within the city. There's an element of race that's here that you must hear. These people are here to do that. They're targeting black clubs and clubs that cater to black and brown and people of lower income strata, as the video will show. We have dozens of examples of white clubs that do the same thing and worse, except they sit on the bid and they don't get the same kind of treatment we do. It's the evolution of racism, ladies and gentlemen. They're not beating you anymore.
Thank you very much.
They're not hosting you anymore. They're taking your businesses away. Next, it's going to be your barbershops. It's going to be your restaurants. It's going to be your stores.
Mr.
That's
Ayaz, your time is up. Thank you. Sean Rafahite. And after Sean is, buried in the public comment cards was a card by an LAPD officer, Habib Munoz. You could speak after Mr. Rafahit, if you can, please. If you so wish to still speak. And as is protocol and policy in this committee, the appellants have 5 minutes. All other public speakers have 1 minute, so you will have 1 minute, sir. Sean Rafahit.
Raphael, thank you. Sean Raphael for Cosmos. I'm going to attempt to play the short clip that was referenced earlier by Mr. Ayaz. I'm going to try to do that now. Yes.
Sean, it's not on. It's on there. Sean, it's on there.
Minority, brown and black, and my guests from a lower economic strata.
Rewind it.
I am reading this, that the Lindsay Lohan of the war are now hanging out at the Rusty Mullets. About social, economic in certain neighborhood to obviously treat the fact the LAPD had to set up a tactical plan, makes the area look like an occupied state of emergency. And 6, only light-sized street with which access to the parking lots and garages. Second, the makeup of the patrons was decidedly minority, brown and black, and my guests from a lower economic strata.
Thank you. Your time is up. Thank you very much. Thank you.
The Lindsay Lohan of the war are now hanging out at the Rusty Mullets.
Habib Munoz from Los Angeles Police Department. Welcome.
Good afternoon. My name is Sergeant Habib Munoz. I'm the officer in charge of the Hollywood Vice Unit for the Los Angeles Police Department. My job here today is to speak on behalf of the Los Angeles Police Department's Hollywood Division, the Hollywood Vice Unit, and the stakeholders of our community that are affected by the Cosmo nightclub. I am speaking on behalf of the residents, the business neighbors, tourists, visitors, and the law enforcement officers that are allocated to patrol and protect the persons around this establishment on a nightly basis. It is my expert opinion that the discontinuance of the operation of the Cosmo nightclub and that the denial of the conditional use permit is undeniably crucial based on the club's past history, which has included violent assaults, shootings outside of the club, and the unreliable management and security personnel which have been subject of the numerous warnings, citations, and physical arrests. An effective partnership between the Los Angeles Police Department and the community stakeholders like the Cosmo nightclub is essential to public safety, as we've heard. Regrettably, it is evident that despite repeated efforts to meet with the operators through available community police advisory board meetings and one-on-one consultations, that the Cosmo operators are willing to engage with the police department in any part and to engage with the police department in any type of collaborative effort aimed at improving business practice and enhancing public safety. Due to the impasse and lack of cooperation, the Los Angeles Police Department has been required to commit a vast amount of resources to provide security for both the Cosmo patrons and the Hollywood Entertainment District. Hollywood Division has been obligated to detach patrol units on a regular basis to mitigate nuisance impact generated from the venue, and my office has been required to spend hundreds of hours in the pursuit of provoking legal compliance and operational responsibility with this club. The Cosmo operation has established itself as a massive burden to the Hollywood area community. The Los Angeles Police Department has been consistently forced to allocate resources to manage the crime that occurs as a result of the operation, thereby rendering other areas of the city and community unsecured and susceptible to crime and disorder. The drain on the resources that the Cosmo currently demands, coupled with the violent crimes that have been occurring with increasing frequency in relation to the venue and the blatant and seemingly willful disregard of the legal requirements that regulate the use of the facilities, serve to represent the reasons for why the discontinuance of use decisions is a public safety necessity. I, along with the officers under my command, request that you uphold the revocation of use determination that was issued following the May 10th public hearing. Thank you.
Thank you. Remy Daranula, Marianne Smith, Christina Williams. Are you here to speak? Oh, nobody's here. Remy, calling once, calling twice. Okay, you have 1 minute. Marianne Smith and Christina Williams. Welcome. Each person has 1 minute. Right ahead. Could line up after the other person. Welcome.
Hi, good afternoon. So my name is Moses Hill, and I'm a campaign manager for a publicity firm with Echoing Sounds.
What's your name again? I'm sorry.
Moses Hill.
Moses.
Yeah.
We haven't called you.
I'm in place of Remy.
You have to fill out a new card, sir, and then if you, we don't allow that. So if you could just fill out a new card, we'll get your name and the card. We need those for the record. So if you could just talk to our
Where's the card at?
Right here. Thank you. So so Remy here? No? Marianne Smith?
That's me.
Okay, welcome.
Hello. I just need to fill out a new card as well. I didn't mark to speak.
We have your card here. You could speak. Marianne, are you Marianne Smith? Okay, go ahead. Go right ahead.
Well, I'm here in representation of the nightclub. I've been there personally. All my experiences have been very positive. It's a place that I have frequent before, and I've felt safe, especially as a young woman in Hollywood. I'm always very concerned about my well-being, and I've never felt unsafe. I haven't felt uncomfortable in this area.
Great. Thank you. Christina Williams? Not here? I'm sorry, if you have something to speak to, can you speak to the clerk? Otherwise, I'd be bombarded with questions left and right. Thank you. Harris Brown? Alberto Avila, after Harris Brown.
Good afternoon, Council. I've been in the nightclub industry for 18 years. I'm a promoter. And I've been around since Century Club in Century City, all the way to currently now at Playhouse, Supper Club before you guys closed that, as well as Cosmo on the promotion side. Everything that these officers are pretty much saying happens has happened from the 18 years of me being in the nightclub industry at every club I ever worked at, whether it was an urban club or whether it was an EDM club. Is all the same. I've been to Cosmo, I promoted at Cosmo, and I've never felt unsafe. I never had a situation where I felt I was going to be murdered or killed.
Okay, thank you. Alberto Avila? No, I don't have it.
Hi, good afternoon. My name is Alberto Avila, and I'm owner to the Cosmo. And I'm trying to keep open my nightclub. I work hard to open this club, and I spend more than my life to make money to keep open this nightclub. And I don't know what happened. You guys all the time we have complaints to my nightclub, and nobody contacted me. I'm living in Arizona, and the police department, nobody contacted me. We have my phone number, we have my address, and I don't receive phone calls, I don't receive nothing in the mail. So all the time we need to ask my attorney what's going on in my nightclub. Thank you.
Thank you. Moses Hill, Evan Garrett, and Conrad Straub. Go ahead. Welcome.
So once again, my name is Moses Hill. I'm a campaign manager for Echoing Sounds. This is just a real clear case of discrimination, and I'm not a racist advocate or an individual that complains about discrimination myself personally. But clearly, based upon the investments that want to take place in Hollywood and all the rhetoric that this particular venue has received, it's clear to me that they are being targeted, along with the other 7 clubs in Hollywood that have been shut down for similar reasons. I've frequented Cosmo nightclub, and I personally have never had any issues there. As a matter of fact, the operator of Cosmo nightclub, he's one of the most serious and also strict venue operators in the city of Hollywood. So I really don't understand how any of this could be put on the particular venue. We're here today just to make sure that it's known that the public eye is very aware of what's going on in the city. And we're not willing to just sit by and listen to it silently. Thank you.
Thank you. Evan Garrett. Gentlemen, you with the garb on your head, otherwise known as Herman here in council chambers and every committee that ever happens in this building. If you keep walking up and down the aisle disturbing this meeting, I would ask you to please leave. This is your first warning. We have been advised by our city attorney that all we have to do is give you one warning, and the second time you will be asked to leave this meeting. Thank you very much. Your name is Evan Garrett?
Aaron Garrett.
Yes.
I am a bartender at Cosmo. I've been bartending for 10 years. I take my job very serious. I was cited for serving a beer to an overly intoxicated patron. To my knowledge, this never happened. It was alleged that the customer was stumbling. It was a slow night. I was helping one customer tops at a time. I have not, nor would I ever serve somebody who was stumbling at my bar. I've been through STAR training. I take it very serious. It didn't happen. Actually, the ticket was never filed. I was never arrested. So that's all. Thank you.
Thank you. Conrad, Joseph Perez, and Brandon Sonboyer.
Hi there. My name is Conrad Straub. One thing the cops were saying was that there's all this crime attributed to Cosmo within the entire building area. There's 5, 6 clubs there. There's restaurants. There's nothing else open but clubs, restaurants, and bars. So to say that we are the reason for all these violent crimes, assaults, it's pretty crazy just that you could blame one particular business in an area where there's 6, 7 surrounding businesses of the same nature. The cops say they come in and cite security guards. By our CUP, we only have to have 2 licensed security guards during the week, 3 on the weekends. We could have upwards of 5 security guards or hosts, as we will, but we only need to have 2 or 3 they'll go to the ones that aren't licensed and cite them. But we still do have our 2 to 3 guards per our CUP. And then on New Year's Eve, Cosmo was shut down by the police department, never issued a ticket, nothing. Manager was arrested. Thank you.
Good afternoon, ladies and gentlemen. My name is Joseph Perez, Jr., badge number 1087 of the State of California Department of Alcohol Beverage Control. The information I'm giving you is available on our website at www.abc.ca.gov. On September 10th in 2012, license number 48523-702 was issued to Hollywood Night Group, Inc. During this time, it's on our website as well. They only have current disciplinary action under registration 160-84176. The count was pending accusation for an incident that happened on October 16, 2015. It's still ongoing. There is no further information available. If any questions, that's it. Thank you.
Thank you very much. Brandon, Joel Green, and Fonzel Harris.
Good afternoon. My name is Brandon Stormbridger. I'm speaking on behalf of Sharna Halpern, who is the owner of IO West. We are the club right next door to Cosmo. We have been there for 14 years on that corner of Cosmo and Hollywood since they opened in 2013. In that summer, we noticed a marked decrease in business caused primarily by the sound bleed that comes through their wall that makes it nearly impossible for us to have shows. It's a live comedy show. The addition of unwanted music has not been helpful. That, coupled with the violent activity that has resulted, has made it so we have lost a significant amount of profit in the time since they have been open. Thank you.
Thank you. Joel Green, Fonzel Harris. Joel Green here? No. Fonzel Harris? Not here. Chris Robertson from Council District 13.
Good afternoon, council members. Chris Robertson, Planning Director for Councilmember Mitch O'Farrell of the 13th District. We're here this afternoon to express our strong support for the revocation of the conditional use permit for the Cosmo. As detailed earlier by Planning, LAPD, and in the letter that the councilman submitted to the Planning Department, Cosmo has been cited for multiple and repeated violations of its CUP. The location has also been found on multiple occasions to be a source of criminal activity and other threats to public safety. Obtaining a CUP is a privilege and comes via an extensive public process and a commitment to comply with the terms of the permit. The recurring problems at this location violate the public trust and put a strain on city resources, including the Los Angeles Police Department, City Attorney, Department of Building and Safety, and Department of City Planning. Given the lengthy and well-documented history of conditional use violations at this establishment, as well as the other unlawful incidents, we respectfully ask that you uphold the zoning administrator's determination and deny the appeal. Thank you.
Thank you. Any questions or comments? Okay. The record brought before us, I think, cites extensive incidents of where this establishment has violated several city codes and violated some of the conditions of their approvals. And I think the record speaks for itself, given also the testimony by our officers. So that's all I have to say at this time. Mr. Harris-Dawson? Sure.
I have a question for the zoning administrator. The documentation does seem fairly thorough and seems to cover a long period of time. And I'm just curious from you, this is an area of work that I have a lot of experience with. I've never seen a situation where a business owner, and I've actually been a part of bringing cases where not only were there shootings, there were actual murders. Does the business owner on the first go-round get a full revocation recommendation? Usually they get more security, more lights, more cameras, less hours. as a recommendation. And I'm just curious about the length of time and the sort of ending up at this, what people refer to as the death penalty on the first shot.
Well, at this point, it's discretionary, and if a business or operation warrants, what we do, first of all, we have a public hearing for an imposition of conditions or a possible revocation of the use. So we open it up and we review the evidence and the information that is before us to determine if it warrants going to a full revocation, but that's through the public hearing process after we've weighed out the evidence. Now, plan approval, there were conditions that existed on the property in the 2013 case. However, and the zoning administrator does have the authority to go back and open that case up and as a plan approval and possible revocation action. But in this case, the evidence is overwhelming, as you can see in the documentation, and the resources that have been pulled towards this location where we wanted to open this up for a possible revocation, which we could not have done that under the 2013 case as a plan approval. And in this case, a plan approval, imposition of conditions would have placed conditions on the operation for a period of, short period of maybe, I think it's 6 months, 9 months, 12 months, or 2 years. But in this case, because of the information that was before us and the serious crimes that had occurred on the property and the multiple violations of existing conditions.
And I'm sorry, when you say serious crimes, can you say specifically what you mean?
I don't have the records in front of me. I think you have them, the police reports. I think there were multiple assaults on the property that occurred between the time frame that I stated earlier. There was a stabbing or an assault with. There was fights. There was. Those are the type of criminal activities, and you would have to refer to LAPD for more details on that because it is in the report. But that, coupled with the violations of the 2013 CUP, the multiple violations and ongoing violations and lack of correction of those violations, it was determined that we had enough evidence, enough documentation to open up a possible nuisance abatement revocation case.
Sure. So would you say it's typical for you for places that there are fights, stabbings, or shootings to come out with a recommendation for revocation at the first hearing?
I wouldn't say it's typical. I would say, again, it depends on the evidence and the location and what the violations actually are. But with this case, there really were any viable options. A plan approval wouldn't have been appropriate. They were not abiding by the existing conditions that were already in place.
Right. But most businesses that get hearings are violating some part of the law, some part of the conditions that they have in business. And so, just as an example, you say no conditions were viable. Could you have said you have to close at midnight? Could you have said you have to have 5 security guards instead of 1? Could you have said you had to have a camera system that LAPD can tap into at all times? I mean, these are the typical kinds of conditions that I hear in cases that are, frankly, worse than this in terms of the severity of crime. And I'm just trying to get and I looked through the police reports that you provided to us. And frankly, there were a lot of police reports, which I didn't even know the police department would do. Police are doing citations because the company had flyers, which is definitely a violation of their parole for sure. I just didn't know you'd get a police officer to do that kind of documentation. Typically, police ask for more serious things. And there, in the stack of police reports, I counted at least 6 times where actual LAPD officers on our city dime used time to document that a business had flyers, which, again, clear violation of their conditions, but typically, and again, I'll just say it outright, in my part of town, we can't get police officers to do that, to spend their time that way. And so I'm just curious about, was there a review camera system, more security, more lighting, changed hours? Was there anything other than you got to be out of business?
Well, in this case, again, looking at the evidence that I had before me and the frequency of the violations of conditions, it was my determination at that time, and because of the violent crimes that had occurred, the sexual assault, the fights and things that were going on the property and in the area, on the adjacent properties, it was my decision that additional conditions would not bring about the results that were necessary. Thank you.
There's been a motion to deny the appeal, second by Mr. Englander. Any objections to that? Okay, so we'll take a roll call vote on that. We have an objection, so we'll take a roll call vote. Mr. Fuentes? To deny the appeal, right? That's the motion, right? Yeah. Mr. Englander? Mr. Weezer, I'll be an aye. Mr. Harris-Dawson is a no. Okay, we'll move this item to council to deny the appeal and then sustain the entire determination of the zoning administrator in requiring the discontinuance of the operation of a cocktail bar lounge with alcohol sales at the establishment known as Cosmo. That's the action. Great. Thank you. Next item, please.
Would you like to take item 3 or 4 or the zone changes, Councilman? 3. So item 3, Councilman, this is a joint report from the Transportation Department and City Planning. It's relative to fiscal year 2013-14 milestones to implement the bicycle plan.
Do we have staff here on this item? Welcome.
Thank you. So, David Summers, Department of City Planning. And I understand we're just asked to report back on the bicycle plan, the annual report for the implementation, 5-year implementation strategy under the bicycle plan.
Yes.
And so the last report that we had filed, we had presented to Transportation Committee. At this point, the 2010, at this stage we were implementing the 5-year implementation strategy of the bicycle plan. I presented a report with our partners at Department of Transportation. We would give annual report backs on the number of miles that were being accomplished under the 2010 bicycle plan and other programs and strategies to increase bicycling within the city of Los Angeles, or at least the comfort of bicycling in the city of Los Angeles. Since that time, the city has adopted the Mobility Plan 2035, which supplanted the 2010 bicycle plan, and so the implementation protocol under the 2010 bicycle plan was not carried forward. So now that we're under the Mobility Plan 2035, we have a different set of implementation strategies and programs. Some of them are carried forward. Some of them are fairly new under the Mobility Plan, and so we're no longer reporting under this structure of the 5-year implementation strategy.
Okay, thank you. So given that the report is, the new Mobility Plan has a new timeline and program for bike upgrade implementation, we could know and file this report, correct?
Yeah,
that's essentially
that's right.
Okay. So the intent is to note and file this report. We have one public comment card. Thank you. And we'll go to public comment now. Thank you. Just as a reminder, this committee has established the council rules with respect to how long a individual public speaker can speak at this committee meeting, and I'll read that into the record. A member of the public wishing to speak on more than one agenda item at a single meeting shall limit his or her remarks on agenda items to a total of 5 minutes per meeting. Okay. Herman.
A joint department
on transportation. Thank you for the buzzard, because the buzzard reminds me of Jose Huizar, who can't stick to Title II for services, programs, and activities when it deals with bicycle plans and mobility. Path to travel. What moron can't figure out how to create a systematic plan that works on behalf of all of us instead of creating programmatic denial of access? Such a moron can only come up with a mobility plan that doesn't work for us all. Under 29 U.S.C. 794, Section 504, the Rehabilitation Act of 1973, don't you fucking get it? And for the record, based on my reference to ada.gov, 16 BRIZG 2P15. That's my complaint against Jose Huizar denying me access to public meetings and not allowing me to speak on bicycle plans and mobility plans and anything that has to do with pedestrian walkways, asshole.
Thank you. So we'll note and file this item and go on to item 4.
Sure. Item 4, Councilman, this is a City Planning Commission recommended proposed ordinance. It's to basically provide a reduction of parking spaces when parking is displaced as a result of the mandatory seismic retrofit ordinance.
Welcome.
Good afternoon, Commissioners. Lucy Butter with the Planning Department. Before you is an ordinance to establish a code amendment to address parking reductions that may occur as a result of compliance with Ordinance Number 183893. The ordinance was established to require mandatory or standards for earthquake hazard reductions in existing wood frame buildings with soft, weak, or open front walls and existing non-ductile concrete buildings. The provisions of Section 1221 in the Municipal Code will be amended to permit the Department of Building and Safety to allow parking reductions not to exceed 20% of the required parking spaces or one space, whichever is greater, as part of their enforcement of the necessary retrofits to these types of structures. Since the City Planning Commission's recommendation, I understand Housing has additional language that they would like to be considered and included as part of that code amendment, and they are here to speak to that matter. If you want, she can include that language now for your consideration.
Sure, yes, we could, please.
Good afternoon. Marcella DeShirley from the Housing and Community Investment Department. The Housing Investment Department enforces the city's rent stabilization ordinance program. We understand that in some cases, the seismic retrofit work will require the loss of parking spaces. However, under the RSO, tenants who have parking spaces included in their rent must be compensated by the landlord if they lose their parking. HCIDLA recommends that the draft ordinance should be amended to include language to state that when a reduction of a parking space is required as a result of compliance with this mandatory seismic retrofit ordinance, that it include this exception does not nullify any existing obligations under the rent stabilization ordinance in Chapter 15, Article 1 of the Los Angeles Municipal Code.
Thank you. Now back to planning staff. Since the implementation of the mandatory seismic retrofit ordinance, how many applicants have submitted plans to undertake the upgrades?
At the time that City Planning Commission considered the matter, and that was as of July, there were 100 voluntary seismic retrofit plans that had been submitted. And a majority of those have been able to meet the code requirements without necessitating a loss in parking.
Pardon me, say that again?
So as of July, there were approximately 100 voluntary plans to do the mandatory retrofit, and a majority of those have been able to do the mandatory retrofits without resulting in the loss of parking. We don't anticipate this to be a regular loss. We just wanted to establish a mechanism so that property owners who are implementing these mandatory retrofits aren't required to then file for a variance in order to make the mandatory fixes.
Okay. Thank you very much. Questions or comments? Seeing none, we'll go to public comment. Herman?
Well, really, are we under the category of mandatory retrofitting? Why wasn't there any mandatory retrofitting for Cosmo nightclub to prevent the sound walls from breaking through to the other businesses? But instead, you get who other than Mr. Dawson to put down his people and not fight for their rights under Cosmo
Sir,
nightclub.
this is about retrofitting.
This is dealing with parking spaces, sir.
Let me
It
finish.
deals with parking
Herman, let me
spaces.
finish.
Well, stop the clock.
Let me finish, sir. This is about retrofitting. You've been warned. You're going to get close again. You know the rules. Stick to the rules.
Mr. Weezer, this should serve as Mr. Herman's second warning.
Yes. Okay. You got it, Herman. You know.
So under section 1221, Article 2, Chapter 1 of the Municipal Code, you again subject people to more harm by the required loss of space for parking. Why do you fools not negotiate better terms with the public so that there's no problems with the parking? Because otherwise, Chipmunk interrupts when the chair is trying to address an issue with me, which has to do with the compliance of mandatory seismic retrofit ordinance. And keep the last fucking 3 seconds.
Thank you very much. Always a pleasure to hear you, sir. Any other questions or comments? No? So we'll move without objection to adopt the findings for a categorical exemption and request the city attorney to prepare and present the ordinance to include the amendment language. This exception does not nullify any existing obligations under the rent stabilization ordinance in Chapter 15, Article 1 of the Los Angeles Municipal Code, as requested by the Housing Department. See no objections? Yes, City Clerk.
For the record, was that the approval with the amended language from the Housing Department?
Yes, that's what I read. Is there anything else that needed to be added, or is that it? That's it, right? That's it. Yeah, that includes that. So ordered. Thank you. Item number 5.
Item 5, Councilman, this is a zone change ordinance. It's for the demolition of an existing single-family dwelling and the construction up to 26 units, apartment units in CD2.
Welcome.
Good afternoon, commissioners. Good afternoon, Councilman. Tom Glick, Valley Project. Yeah. Oh, it does go up? Yeah. Okay. I like to bend down. Good afternoon, Councilman. Tom Glick, Valley Project Planning. I'm going to say a few words because this case didn't have the benefit of an APC review because APC canceled their meeting the day of the item. So I want to present this presentation abbreviated that would have been given to the Area Planning Commission. Essentially, the applicant is requesting a zone change from R1 to RD 1.5 to have a base density of 19 units and then 7 additional units under a density bonus provision. At my public hearing, there was little opposition. There was actually support from the neighborhood council. The council office supports the project. So I saw no reason not to recommend what the applicant requested with T's and Q's. One thing I will amend that I would have amended at the time for the Area Planning Commission was the condition number 32, the indemnification condition. I made a mistake. I put a partial condition, not the full condition, and I would recommend that the indemnification commission be included in its entirety, not the partial one. Other than that, the applicant is here. I've asked the applicant to give a presentation that he would have given to the Area Planning Commission. The applicant is here to make that presentation if you require it. They've submitted a card. Other than that, thank you.
Applicant wish to speak. We have a card here. Armin Garay.
Good afternoon. My name is Armin Garay with GA Engineering, representing the owners on this project. We have an infill project on a street that's pretty much already developed with multifamily dwellings. This is one of the last remaining lots that is not improved with a multifamily dwelling. We are requesting a zone change to conform with the general plan for RD 1.5. We are asking for a density bonus. We've already met with the council's office, with the neighborhood council. We had 3 different meetings with the neighborhood, and we've taken all their views into consideration. We've made some changes to the plan. We are providing parking above what's required per density bonus laws. So we're not even getting any reduction in parking. So it's just the only thing we're increasing is some density units, and we're providing 2 units at a very low income. I think it's a good project for the neighborhood, and we appreciate your approval. Thank you.
Great. Thank you very much. So you had an amendment, the planning staff, to what was the suggested recommendation?
Yes, I recommend that the staff report, because Commission didn't act on this, their recommendation is silent on this. I recommend that the condition 32 that was sent over be amended in its entirety. We've provided the indemnification condition that is the current one that's being used in all our reports.
Okay.
So it was a partial one, and now it was submitted to the city clerk.
Excellent. Well, we'll incorporate that. We'll incorporate that into a motion to approve as amended by the Planning Department staff to adopt the MND and adopt the Planning Director's recommendation to approve the ordinance affecting the zone change. That's the motion before us. Let me take in public comment first. Herman?
On this item of number 5 in Paul Krikorian's area, CD2, we're talking about a planning commission's relative draft ordinance to effect a zone change. How many inconsiderate zone changes has this panel of men made mistakes with? Just no more than 2 weeks ago, I was standing in here being threatened by Jose Huizar regarding my complaint about how these demolitions of so-called zoning areas are targeted by Jose Huizar and his developer.
Mr. Herman, you are now going to be escorted from this meeting. If you wish to speak generally about zone changes, speak in public comment, but as of today, this is your 3rd warning. I'm going to ask our officers to please escort you out of this meeting. Thank you very much.
I'm reading it from right here.
You are being asked to leave this meeting. Thank you.
Oh, so then I don't get to speak on general public comment? No.
Mr. Huizar, maybe for the good of the order too, the pig and his puppet over there also were not here in the room when the admonishment was given about interrupting the meeting. So I think it'd be for the good of the order that we could admonish the pig and his puppet there too.
Sure. I agree with that. We do have Wayne Spindler now next.
Mr. Chair, for the record, it should be noticed that Mr. Herman is also still disrupting the meeting on his way out of the committee hearing.
Thank you. Mr. Spindler, you've submitted 2 different cards, one with your name and one with, it says me. I suspect that's you.
Yes.
Which cards do you want me to use?
Well, I was hoping that both the pig and my friend could talk.
Sir, I'm asking you a very direct question.
Well, we'll go with the me.
Okay, if I don't get an answer from you, I'm just not going to call any of the cards up. What do you want me to call you when I call you up?
Me.
Okay, thank you. I will disregard the other cards for the record. Thank you.
Very good, thank you. Now, let's talk about the North Valley Area Planning Commission and what a bunch of fucking scumbags they are. Because you see, Pepita Pig, go to the NVAPC, and I know it's a dysfunctional planning commission with cocksuckers that run it.
Sir, Mr. Spindler, this item is about a particular property where there are some entitlements they are seeking. Please speak to that. This is your first warning. If you go off topic again, you will be asked to leave this meeting. Thank you.
But the agenda item says on April 21st. Correct, Mr. Dawson? The NVAPC failed to meet due to lack of quorum. I'm on the topic. And that is why we are here, and that is why Mr. Uzi is over here today. He had to spend all his time driving here because your planning commission is a dysfunctional bunch of poops. So please give this man every consideration, fine gentleman, and a fine weapon company. Thank you.
Okay, so on this item, we will adopt the M&D and adopt the planning director's recommendation to approve the ordinance affecting the zone change as and with the correction as submitted by the planning department. Any objections? Seeing none, so ordered. Item number 6.
Item 6, Councilman, this is a Planning Commission recommended zone change ordinance. It's for the construction of a 5-story, 51-unit independent living senior citizen housing development in CD 11.
Okay, welcome.
Thank you. Good afternoon, council members. My name is Sheila Gershon with the Planning Department. The project is located at 3960 through 3966 Grandview Boulevard in the Mar Vista area. The project is a 5-story senior housing development with 51 units reserved for independent living senior citizens. Currently, the site is split zoned with M1-1 and R4-1 and is inconsistent with the general plan land use of high-medium residential. The applicant is requesting a vesting zone change from N1-1 to TQ-R4-1 across the entire site to bring zoning consistency with the land use designation and to allow for residential use across the entire site. The project is surrounded by similar developments. To the north is a 191-unit senior housing development, and to the south and to the east are other multifamily residential buildings. In closing, the requested actions are to adopt the mitigated negative declaration and the mitigation monitoring program, adopt the vesting zone change, and third, adopt the attached conditions of approval and findings. In order to approve such an action, findings must be made to grant the vesting zone change. In this case, findings were made as the zone change is necessary to bring zoning in conformance with the general plan and to allow for a better use of the site for multifamily, which again is consistent with the surrounding land use. Thank you, and I'm available for any questions.
Thank you. Arthur Bannock, you are the representative for the applicant?
Yes, I am.
Okay, thank you. Welcome.
Good afternoon, council members. Art Bannock, I'm the architect for the project, and I was asked to just briefly let you know that through negotiations between the developer and the council office, the developer has agreed to provide one affordable housing unit on this project, which wasn't required by the code. And that's it. If you have any questions, I'm here.
Thank you. Okay, someone who submitted a card by the name of me.
Thank you. Now the elderly, dependent senior citizens will now be living in CD11 in rooftop penthouse units. Yay! Imagine spending your golden years near the ocean with your rooftop penthouse ocean view. Thank you to the developer for making affordable housing by the beach. This is very good, and I know this will pass unanimously. I know a lot of you want to vote no. I can see the heresy, the doubt, but I know that you'll come around and get 4 votes. And I know that Bonin will be happy. Everybody will be happy. 57 bicycle parking spaces are not needed because people that are old can't ride a fucking bike without falling down.
Ezra Gale from CD11.
Good afternoon, council members. Ezra Gale for Council Member Bonin.
an acknowledgement of the agreement which was reached with the applicant. We've submitted some revised queue conditions. We ask that you approve the project with those amended queue conditions. Thank you.
Thank you. And there are some revised conditions submitted. Did we have those before us? Yeah.
Faisal Roble, Planning Department. We consider this change as a third-party agreement between the council office and the applicant. Okay. However, we are more than willing to memorialize this agreement in part in our document, but we don't consider this as part of key condition to be revised or changed.
Okay, sounds good. So we'll move to adopt the MND and approve the zone change with the revised conditions. Any objections to that? Seeing no objections, that is so ordered.
And the affordable unit, right? Yeah.
Yeah. No. This is the item, the written.
Right.
Actually, that's something that the council office submitted. However, we don't consider this as an affordable. It's a 150% AMI, which is not really affordable, and there was no condition of affordability to the zone change. So we don't mind to accommodate the third-party agreement between the council office and the applicant, and we would like to memorialize that somewhere as part of the covenant in our case file.
Adrian Corsani, City Attorney's Office. So I think correct me if I'm wrong, I think that there is a third-party agreement that the parties are willing to enter into. It doesn't necessarily
Have
involve
to be part of this.
Doesn't have to be a part of this, and it can
Gotcha.
be part of the file.
Okay, sounds good. So ordered accordingly. Okay, thank you. Next item is public comment. Right, public comment, Roberto. Okay, we have me.
Thank you. Reference number 16 BRIZG-2PL5. ADA complaint. Armando Harmon against Jose Huizar for throwing him out of all these meetings so incredulously. Shame on the chair for violating the
Mr. Me, this has to do something with planning and land use in the city of Los Angeles, okay? And so if you could just stick to that, we'll happily listen to you.
Very good. Now, turning to the North Area Valley Planning Commission, scumbags need to all be thrown out of that commission, because every time I go there, either there's not a quorum or they order a salad lunch catered. The only goddamn commission to order a catered lunch on taxpayer expense for this useless fucking commission. Absolutely disgraceful. Finally, please allow Armando Herman and his puppet to attend the future meetings. Thank you.
Thank you. I think we just lost quorum either way. Thanks. Thank you very much. Meeting adjourned.